through partners, they analyze you on 2 years rates. They don't do compensation anymore, we go 2 years. So you can kind of.
Would all those present in the courtroom please rise? The Utah Supreme Court is now in session. The Honorable Justice Paige Peterson is presiding.
Hi, good morning, everyone. I am going to be presiding today because Chief Justice Durant is joining us remotely, so you can all see him up on the screen. I think this is the first time that we have had an oral argument where one of the justices is remote. So, Chief, it's all on you to show how this works. Could I get the parties' appearances first? First, we'll have the appellant.
Good morning, Your Honor. Michelle Quist for Appellant Utah Stream Access Coalition. With me is Sean Welch and Craig Coburn.
Good to have you.
Thank you, Your Honor. Nathan Thomas and Liz Butler on behalf of VR Acquisitions, LLC.
Okay, it's great to have you. And I'll just explain for the audience and counsel.
One more.
I'm so sorry. Go ahead.
Andrew Dimmick for the City of Utah.
Okay, thank you. Just so everyone understands, we have time limits for oral argument, but we often continue asking questions. So if your time is up, but we still have questions for you, it's okay for you to keep answering those questions, and it won't count against your time if we keep asking questions, okay? That sometimes means that one side gets more time than the other, and that's just a function of the fact that we may have more questions for one side. Doesn't necessarily give anyone an advantage or not. So don't worry about that. And let me just ask, in terms of timing, how do you want to divide your time today?
Your Honor, I've reserved 3 minutes for rebuttal.
Okay.
And Your Honor, the state and VRA have agreed to split their time equally, 10 minutes apiece.
Okay, great. All right, I think we're ready then.
Good morning, Chief Justice, Your Honors. May it please the court, Michelle Quist for Appellant Utah Stream Access Coalition. The Utah Constitution and Utah courts recognize that Utahns own the public waters, but ownership of the waters without the ability to use them is worthless. The 23-mile stretch of the Provo River in Wasatch County is a beautiful wooded stretch that crosses, at times, Victory Ranch property. The river is ripe for recreation use, including canoes, kayaks, and anglers who necessarily touch the bottom of the riverbed, incidental to their recreation use. For this, Victory Ranch and the state want to prohibit public access and prosecute members of the public, and specifically members of the coalition, for trespass. But the Constitution protects the public's right to touch the riverbeds, as did this court in Conitzer v. Johnson until it was superseded by the Public Waters Access Act in 2010. As a practical matter, the act closed more than 2,700 miles of rivers and streams where they were open before. We are here today seeking reversal of summary judgment in an answer to this court's mandate given almost 3 years ago, where the court asked us to address the threshold question whether there is a historical basis in the understanding of public easements in the late 19th century for the easement the Utah Supreme Court recognized in Conitzer. The answer to this question is yes. In fact, the coalition took the court's mandate seriously and spent a tremendous amount of effort answering this question, digging through historical records to find out how the people lived and what they understood relating to their access to public streams, pre-statehood and post-statehood. Hiring experts and presenting this evidence and legal authority showing their understanding of territorial Utahns' access to public waters. Instead of wrestling with this evidence, the state and Victory Ranch made a concerted effort to have the district court ignore what was happening regarding public stream access in the 1800s and early 1900s, and made no efforts of their own to elucidate the issue, and instead fixated on one case, Harkness v. Woodmansee.
Ms. Quist?
Yes.
It struck me that your showing was quite good in terms of what was the practice and understanding back in 1895 and thereabouts. At the same time, it struck me that that showing was not necessarily inconsistent with permissive use, as opposed to use as a matter of right pursuant to an easement. I mean, back in 1895, the people fishing the Provo River are not, as now, wealthy doctors from Southern California who fly into Heber Valley Airport on their personal jets, fish for the afternoon, and then are home in time for dinner. It would have been your friends and neighbors, your fellow ward members, the person that helped you get your hay in last fall when you were laid up, the family whose wife helped your wife deliver children three through 6. I don't think it would have occurred to the pioneers to run somebody out of their riverbed that was their friend and neighbor. But there weren't armies of tourists coming in and making use of that. What is there in your showing to suggest that those who were using the riverbed in 1895 and thereabouts were doing so pursuant to their legal easement right of access rather than because of their sort of collegial communal understanding, share and share alike? Sure, come fish on my riverbed, and thanks again for helping me get that hay in. I didn't see a focus on that.
Well, the communal understanding came from the public right to the water. And the public right to the water was the legal right. And that legal right was recognized throughout the laws, throughout the traditions, and the traditions came from that public understanding and that public right. And that public right was what was then the focus of what was then protected within the legal framework of what our showing entailed.
Well, it was definitely a common custom and practice, but what transformed it into that unique legal right that comes with an easement?
Article 17, for one. Article 17 enshrined that right as a public right. And incidental, it's just, Article 17 states that the public has a right to the water.
Is Article 17 still a live issue? I thought the district court ruled on that, and that hasn't been appealed.
Well, Article 17 states that the public owns the water, or the public has a right to use the water. And that wasn't, and that's a right throughout the state, throughout the cases, that is still a public right. And
But didn't the court rule that the easement that you're claiming did not come about connected to Article 17?
the easement is not connected to 17. It's just an incidental right along with the use of the water. And so the use of the water was protected within Adams, and Adams recognized Article 17. And Article 17 recognizes this public right to use of the water. And incidental to the use of the water is a touching, right? So the public can use the water, and incidental to that use is a touching of the stream bed. And the people can use that water through, and that's recognized in Adams, and then it continues throughout the case law and the statutes of the time.
Okay, let me just make sure I'm clear on this. I thought that the court had already dismissed, like before even the first appeal, the Article 17 argument or claim, and that we were solely proceeding on Article 20. Is that correct?
We are proceeding on Article 20, but Article 17 still recognizes a public ownership of water. And that public ownership of water is alive throughout the case law.
But you would agree, I suppose, that the right to water is different than the right to the land, which is the stream bed. Is that right?
Yes.
Okay.
Yes, but the right to water was alive throughout this time period, and the right to water was alive in the territory. This was the territorial right. This was the legal framework that existed at the time. This is what the pioneers understood as their communal understanding. This is what we were mandated to go and look for. And so the pioneers understood that the public owned the water.
But by owning the water, do we mean owning the right to actually use the water, divert it, water crops, use it for culinary purposes? Isn't that what we mean by that kind of water right?
Any beneficial use. And so a beneficial use includes recreation, is what our case law has shown. And incidental to that recreational use is a touching, is what we're arguing today. But we're not arguing that Article 17 allows the touching. We're arguing that Article 17 created the framework during the territorial time wherein the pioneers understood that they were allowed to go and fish in the streams and the riverbanks. That they were allowed to go, and not necessarily just go in their neighbors' yards or go in the streams because it was a neighborly thing to do, but because the territorial laws allowed them to, not only allowed them to, but protected their right to, because it was a territorial right. It was a communal benefit of the people of that time period to go and use the waters of the territory for commerce and to feed their families and to, build their homes and feed their families.
Let's assume that you're showing, and I agree with Judge Orm that you made a very good showing of how these rivers were used at the time we adopted the Constitution. But let's assume that it wasn't just permissive, that everybody sincerely, the public believed that they had a legal right to wade on these stream beds for fishing and for other purposes. Does the public's belief that they have a legal right to something, is that enough to create an easement over private property?
Well, that was our mandate. Our mandate from this court was to go and show the understanding of the public at the time. And the understanding of the public at the time was that they could go and legally use the public waters for that right.
Right, but my question is this. Even if everyone, the community generally, believes that they have a right to do something, does that actually give them a legally enforceable right against a private property owner? I mean, for instance, let's say that everyone thinks that this plot of land is owned by the government and that it's open to the public, but it's not. Does the fact that everyone believes that it is and that they have a right to cross it create a property interest that they can enforce against the private property owner?
During territorial times it did. When you're beginning a state, it does. When you're granting land patents, it does. When you're saying we're creating a new government and here's a land patent, we give you this land patent and we recognize all of the customs that came before and all of the laws that the state recognizes before are still in effect. Here's the land patent. Now go and continue on in your community. It very much does matter what the community understood as to what the laws meant, and what the community understood as to what they could legally do. That's exactly why the court asked the question.
I think the community back then would have been baffled at the idea that you're free to come and use the river for recreation and fishing and so forth, just don't touch the rocks and moss.
Completely baffled.
They would have been very confused at that concept.
It would have been impossible. It would have been impossible to to fulfill anything that they had been doing before. And in fact, the trajectory of cases, you've got Adams to JJ&P to Conitzer, which was overruled by statute, but how could you have had the trajectory of those cases, which shows Adams says that you had a public ownership of water from before the statehood, from before statehood. How could you have this trajectory of the public owns the water, but somewhere in there you can't touch the bottom of the river, and then you can touch the bottom of, like, where is the disconnect? The trajectory was one way, and it started because the territorial Utahns created this community out of an understanding that they all shared in common the resources that they crossed oceans and traveled on pioneer wagons thousands of miles and came to a desert land that nobody wanted, and there was no water. And the case laws, the cases make clear that they came here and because nobody wanted it, and they made a beautiful desert rose, and they did so because they shared resources.
Ms. Quist, can I ask you, I want to make sure I understand the district court's ruling on Article 17 that is still the law of the case. So my understanding, and as always happens, I know I highlighted this in the, and I can't find the specific language.
Yes.
Despite my looking. So my understanding is the district court said, yes, in Article 17, the lands are public and there is an easement. I'm sorry, the water is public and there is an easement to use of the water. But that the act doesn't violate that because the legislature is allowed to regulate that easement. But the court recognized that the water is public and that there is an easement to use the water. Do I have that right?
That is correct.
Okay. So my question is that it seems like a lot of the analysis is different than our usual constitutional analysis, because what we normally ask is, what would the public understanding of this language in the Constitution have been? And a lot of the analysis has been, what was the law, right? But it's certainly relevant what the law was at the time, but our constitutional analysis takes a lot of different pieces of the puzzle, and we have to decide based on customary use, what the law was, what does the language of Article 20 mean, what would it have meant to the people of Utah at the time they ratified the Constitution?
Right.
So could you speak to that a little bit? I mean, to me, it seems like your evidence that I don't think anyone's disputing that the easement has always been, has always included an ability to touch the riverbeds from the time of statehood, that the use of the water, maybe not I shouldn't use the word easement, the customary use of the water included touching the riverbed. So that seems to be a very important clue about what the public would have understood at the time. Can you talk to us about just in that language? Because I haven't seen as much of that, just in this language of what would the public have understood the meaning of Article 20 to have been at the time they ratified the Constitution?
Well, I think the responding parties have disagreed with that definition of the easement. And I think that's what we've concentrated our briefing on. And I don't think we've briefed yet the next step beyond that threshold question, which was the next questions. We're happy to do so. I think the people would have understood that the Constitution at the time would have accepted this part of the easement because it was so ingrained in what their daily life meant. that their daily life entailed, and that any that their laws entailed. We had our declarations, our evidence showed statutes that talked about the fact that there weren't trespass laws relating to the fact that they could go and fish. It's hard to prove the absence of, you know what I mean? Whereas in other states, there were cases that defined a landowner's right that they owned the exclusive right to fish. That didn't exist in Utah. In Washington, there was a case. In Colorado, there was, the case that said they had the exclusive right to fish. That didn't exist in Utah. And responding parties couldn't show those cases from Utah because that's not the way the Utah territorial pioneers were living. And so the Constitution would have, Article 20 would have had that same types of definitions. But honestly, we haven't briefed those questions yet because our briefing focused on this one threshold question. We would love the opportunity to brief those next 4 questions rather than going back down to the district court and coming back up. We think there is enough in the record for the court to decide the threshold question in the affirmative. We think that that's what the court should do. We think the court should decide that there is a historical basis to decide that the threshold question has been answered. There was a legal basis to show that there was a connoisseur type easement at the time of the territorial pioneers living.
So for the threshold question, the question of is there a basis in historical fact, whether there is a basis in historical fact in the understanding of public easements in the late 19th century for the easement recognized in Knatzur, and the understanding as you focused on it, as the parties have focused on it, is not, you focused on the public's understanding, but it seems like the court focused on, well, was it recognized in law?
Correct.
Is that correct? And so the court didn't move on to look at whether it was acquired and accepted by the state. It was just whether legally it was recognized.
Correct. And in fact, the court required us to state a case or state a law. And of course, there isn't one. If there had been one, the court would have decided this itself in 2019. There isn't a case, and there isn't a law. That's the whole point, is that there was no single case that said you can't, that the landowner owns its own fish, or the landowner can exclusively fish, like there was in Washington. There isn't that type of case. And Harkness isn't applicable here because it doesn't deal with public property. It doesn't deal with public waters. It deals with a single landowner's private property and the right to put a fence up or the right to move land. It doesn't deal with the facts at issue here. And the district court's other issue about federal land grants also doesn't apply for 3 reasons. First, the position ignored, I'd love to go into it and make sure I hit it. First, the position ignored the facts presented by the coalition's experts related to grants issued after 1869, but before statehood. This is the federal land patents. The district court argued that federal land patents cut off any prior easement rights, right? That it gave all land rights subject to, just free and clear of anything. But it ignored the fact that any grants issued after 1869, but before statehood, might have recognized easements granted within that period, and therefore easements were, being recognized before statehood. It just completely ignored that whole time period. Second, the position ignored the reality that when the United States confirmed title to lands, it did not destroy the right of the public to enjoy the uses of public waters. In other words, the property had already been subject to the public's easement and public waters. And the New Mexico Supreme Court had this entire discussion already in Adobe Whitewater Club. And of course, this had to be the case because This is how the people were already living. They were enjoying the use of public waters. The federal government wasn't going to come in and take that away because civilizations have always outpaced government. Government always has to come in and catch up to what the people are doing, right? And so it's absurd to argue that the territorial Utahns were using the public rivers and streams communally prior to 1869, and then the federal land office issued land patents, and all those rights were thereby exercised, and everything just like started over from scratch.
We're getting near we're
I
out of
covered my
time. Are
clock.
there any other questions? I just
I
want to
think
make
the
sure.
chief had one.
Chief?
Chief Justice.
Yes, thank you. So, Ms. Quist, your argument, as I understand it, is, first of all, everyone, I think, seems to agree, or certainly the district court agreed, that you have gone above and beyond in establishing that there was a pervasive practice of Utahns touching stream beds as they exercised their constitutional right to recreate in waters. So everyone was doing it. And what do you suppose if a 19th century Utahn had been asked, what is the legal basis for you doing this? I think your answer might be, well, basically everybody's doing it. It's part of the communal atmosphere. It's just done. It's just understood. And that was the understanding of Utahns. And it sounds like you were also arguing that the federal government did not have complete or plenary power over federal lands during the period in which it was granting land patents, that those patents were subject to these easements to touch stream beds that had been developed as a matter of kind of community attitudes, religious attitudes, general practice. Have I stated any of that incorrectly?
No, Your Honor. I would agree.
So the state, of course, argues that it's generally accepted in U.S. law that community understanding cannot serve as the basis of an easement. And why? What is your argument that it would be different in this case?
Well, I wouldn't say it's community understanding as the basis of the easement. I would say it's the ownership of the public waters territory in territorial times prior to pre-statehood. And so with that ownership of the public waters comes a right to use those waters, and incidental to that right of usage is a incidental touching of the riverbed.
So do you accept that the federal government, I guess during the period up to 1869, owned not just the land but the waters?
Yes.
But the waters were subject to an easement by virtue of the community understanding. So there were limitations on the power of the federal government during the period in which it owned the lands and the water.
Yeah, the federal government didn't have a federal property rights. The federal government might have owned the land, but the state and the territorial still had property, laws that it could access or that it could prosecute against its people. You still had private landowners or once those patents were granted, the land was subject to state or territorial laws. And while you couldn't prosecute an easement against the federal government, you very well could prosecute an easement against a private landowner.
So if the, and I know this didn't happen, but if the federal government had said, we're granting this land title and this title to any water that runs over the land, free and clear of any contrary claims, even from not just the federal government, but from private owners, would there have been some legal limitation on the federal government? And if so, what would it have been?
I can't think of a legal limitation against the federal government, but once that patent issued, that land would have been subject to territorial laws. Number one. Number two, well, that would have been the answer to your hypotheticals. That land would have been subject to the territorial laws that were then in existence.
Did the federal government have the power in granting a land patent to say, you have title free and clear, and this title is superior to any territorial laws?
It did.
But you don't think you think the fact is it did not, that the assumption was at the time that these patents were subject to established community practices, at least relative to the use of or to the touching of stream beds.
Yes, I think there are two caveats. Number one, they were subject to the community standards based on the Mining Act, the statements in the Mining Act of 1866 and the Desert Land Act, which specifically stated that land patents are subject to territorial customs already in effect. And two, those land patents were issued in 1866. There was still plenty of time for easements to enter the property or enter the land before statehood.
Thank you, Ms. Quist.
You're welcome.
It's very
If there are no more questions, I'll be back on rebuttal.
Thank you.
Thank you.
Chief Justice, Justices, Judge Orm, thank you. May it please the court, I'd like to begin today putting this appeal a little bit into context in light of the last decision and what transpired at the trial court level. For 12 years, our client, a private landowner, has defended this case. And on the first appeal, the court made clear that Knatzer, Adams, JJ&P were all the product of 20th century common law. The rule stated in Knatzer was not a constitutional right as it was then defined. Now, USAC, the appellant, appears to advocate that this court should revisit that decision and find some or any constitutional underpinning for the right and the easement that it's claiming. But many of its arguments don't go to the one claim that remains in this litigation, which is a claim that the Public Waters Access Act violates the public trust principles inherent in Article 20. That is the only claim that remains. And in addressing this claim, this court previously identified a threshold question. This is not a substantive constitutional question. It is not a question about what Article 20 means at this point. The threshold question is a gatekeeping question to determine.
Judge Pullen seemed a little perturbed, might be strong, but annoyed at least that the court had stated the threshold question 9 or a dozen different ways. Is that just a semantic rephrasing? Is there something to Judge Pullen's concern that he didn't get the guidance from this court that would have been most useful for him?
I mean, I appreciate that question because there's been a reference to custom and historical and public understanding versus a threshold question, which I think is probably most accurately stated in paragraphs 88 to 91 of the court's prior decision, which indicate that it should be an easement that was dictated by the laws of the 19th century. That is, we need an application of fact to law in order to establish a legal entitlement. I think if we look at paragraph 89 and 91, I think that's clear. And that was the basis for Judge Pullen's decision to treat this as a mixed question of law and fact. I hope that answers your question, Your Honor.
But we also said that this was a question of historical fact also. And I think that our explanation of Knatzer was not that we determined that we had decided this was not constitutional. It was that we hadn't been asked that question in Knatzer. And so that was applying common law principles, but for a constitutional claim, we would need to do the originalist work of deciding the public understanding at the time of ratification of the Constitution, which is always a combination of all sorts of different sources, but primarily public understanding. And I realize this threshold question has been treated not as analyzing language of the Constitution, but in talking about the understanding at the time, would you agree that the evidence seems to show that the public understood that that the water was public, that they could use the water, which included all sorts of uses, and touching the stream bed was one of those, and it was not illegal. It was legal, they were allowed to do it.
I don't know that I would agree with that in its entirety. I would
Okay.
agree that the evidence presented by USAC, which was not disputed by us at the trial court level, showed a common use of a certain segment of the population of the beds of non-navigable streams that were privately owned. The difference, I think, becomes that public understanding alone, a belief system alone held by a certain portion of the population, does not necessarily give rise to an enforceable legal entitlement. And when we look at Article 20, what we have is a section that applies to lands of the state. And in the prior decision, the court emphasized the need to prove at a minimum a legal interest in land, which is an easement. Now, an easement doesn't exist simply because someone believes I can do something or because of permissive use. I can walk across my neighbor's lot all day long. That doesn't alone give me a right to establish and enforce that in court. Now, by referencing all of this, the common understanding and the public understanding, it's not like the courts in the legal system were wholly undeveloped. The court system was cognizant of methods by which to prove an easement by prescription, by condemnation, by dedication. These were all referenced in Harkness, along with the presumption that use was permissive under that time. That's one of the principles of Harkness, which is not a case that was brought to the trial court by USAC, notwithstanding that it was its burden to show a legally enforceable interest. Because if there's not an easement, a legally enforceable interest in land, there can't be a land of the state that is subject to Article 20. If we go back to the prior decision, this court didn't decide if an easement alone as a legal interest in land would be enough to qualify as a land of the state. But that was the starting point.
So let me see if I understand your argument correctly. At this point, we're not deciding a constitutional question. We're only deciding whether there was a legal easement at the time the Constitution was adopted. Because that has to be decided before we start to say, okay, and then was that easement part of the lands of the state that's referred to in Article 20? So we're not asking whether there was a constitutional right to use these stream beds at this point. We're only asking whether there was a legally recognized easement. Is that correct?
That is correct. The way that I view this, and I focused a lot this weekend on the word threshold as a question. A threshold to what, right? And I decided a gatekeeper question is what this is. Is this a legal interest in land? If it is, does that, the next question that has not yet been answered is that a land of the state that is subject to protection under Article 20 or subject to the public trust principles under Article 20.
How did, the district court seems to have rejected that framing though, even though it ultimately decided in your favor, the district court said, this is not just about the law at the time. This is about both historical fact and historical law.
That's correct. We initially took the position along with the state that this should be just decided as a matter of law. Put forward the law that demonstrated this easement existed. The district court disagreed with us, and frankly, in retrospect, I think the district court was correct. Because to prove an easement over time, if we look at Harkness, you must show a pervasive use over a certain period of time that's open and notorious or hostile. Or you need to show the documentation that demonstrates a dedication or an edict of the state that would amount to a condemnation. Those questions are not purely legal. They require an application of fact to that law. Now here the facts demonstrate a pervasive use or belief of an entitlement to use by a certain percentage of the population that we did not dispute. Where our dispute is that that alone does not create an enforceable right. We look at Harkness, and use was presumptively permissive unless you met these other standards and could therefore be rejected. USAC has said that Harkness doesn't apply, but they haven't given us another legal basis on which the public could, under the set of facts presented by USAC, have amounted to a legally enforceable interest.
I think the argument that I'm hearing today is that the right derives from the right to use the water, that it's necessarily incidental to. And everyone agrees there was a right to use the water, and because you need to be able to touch the stream beds to effectively use the water, that is the legal basis. What's your response to that? My
response to that is that our Constitution, Article 17, does not actually confirm the public ownership of the water on its face. That was a subsequent statute. I'm going back to the prior appeal in 2012 argument, so forgive me if I get something wrong. But in 1901 or 1905, I believe the legislature codified the public ownership of the water. Now, putting aside whether the public owned the water as a predicate, what is the legal basis? My question is, what is the legal basis on which that translates, that ownership of the corpus of the water, an entitlement to dip your cup or water your sheep, translates into a burden on the land beneath it? We have a division of the land and the water. And what this Article 20 argument is asking is, does that public ownership of the water somehow equate to a legally enforceable right to use land?
Can I ask one question that I think is part of, so your statement that that the legislature codified this after Article 17, does that conflict with the law of the case that the district court found regarding the meaning of Article 17?
I don't believe so. I don't think Article 17 comes into play at all, because also initially, Article 17 is not pre-statehood law. That is statehood law, right. Whereas the threshold question you're asked, statehood law. I think that if we go back to the 2012 summary judgment decision by the court, the district court found that there was a use that permitted the touching of the beds along with the public ownership of the water that came along with one of the, let me back up one moment here. Article 17 confirmed existing rights to the use of the water, beneficial uses. The court found that the touching of the beds was among those uses that was confirmed, but it was a right that was subject to regulation by the legislature, and that the legislature did not exceed its bounds in doing that. So I don't think that it's inconsistent, because I think that the court could determine that Article 17 did confirm certain rights of use. That just does not amount to an easement that is subject to analysis under Article 20.
But, and I do not mean to hijack your question.
You're good.
But isn't the question what the scope of the easement was? What the scope of the use was?
I don't believe so, because I believe that the question is framed by this court is, does Article 20 apply? And if so, was it violated? It only applies if the use amounts to an interest in land that is then deemed to be a land of the state. Only if it is a land of a state is it subject to the public trust principles in Article 20. If it's an untethered use or a right that derives from Article 17, that doesn't mean it's subject to Article 20. Article 20 requires a land. That's why the word easement is so important in this case.
So all of this is in the context of a constitutional question, a state constitutional question. So if appellants prove that the public understanding of what they were allowed to do, what was legal, was the full scope of what was later recognized in Knatzer, how does that affect your analysis?
It doesn't, because even if they had that understanding, that does not amount to an enforceable right in land. And unless it's an enforceable right in land, the Article 20 question is done. But I would also note, just because something was common and publicly understood to be permissible in the middle of the 19th century, does not mean that that is a right. There are plenty of beliefs that were held by people in the 19th century that we certainly, even though they were common, even though they were pervasive, are not going to deem them protected.
That's correct, but public understanding is the North Star of our constitutional analysis of our state constitution.
But the law at the time did provide for a method to create an easement. And the facts and the public understanding alone would not have created an easement, and thus Article 20 wouldn't apply.
Is the question before us right now what the public's understanding of Article 17 was, or is the question whether there was an easement, not a constitutional right to touch stream beds, or a right connected to the constitutional right to use the water, but whether there was an easement?
Yes, the question is whether there was an easement. That is the question.
Because this court said in our last opinion that the coalition had put all of its eggs in the easement basket, and unless there was an easement that would have been legally recognized at the time the Constitution was adopted, so that it might presumably fall within Article 20, that's the end.
That's the end. Yeah, if I reference the court to paragraph 89, for example, of the decision, it says, so a public easement dictated by our law in the 19th century is at least arguably a land that was accepted by the state through ratification of Article 20. If the district, skipping to paragraph 91, if the district court determines that Knatzer easement exceeds the scope of the public easement that would have been accepted under the law of the late 19th century, then that may be the end of the litigation. And our position is that these facts, even a public understanding of an entitlement to use, is an understanding of a presumptive permissive use as evidenced in Harkness, and not evidence alone of a legally enforceable interest in land subject to Article 20.
So at this point in the litigation, could this court find that the right enshrined in Article 17 of the Utah Constitution carries with it the right to incidentally touch stream beds in exercise of that right?
I don't believe that that is before the court. That was the subject of the summary judgment ruling in 2012, in which the district court did find that there was a similar right inherent in Article 17, but that the Public Waters Access Act was not a violation of that. It was a proper exercise of the legislative authority. And the only question we have before us is the claim under Article 20. So Article 17 is no longer a basis on which this court could determine that USAC can prevail in this matter.
Oh, Chief, I see you're raising your hand over there.
I'm sorry, Your Honor.
Well, what is the evidence that people in Utahns in the late 19th century viewed their touching of stream beds to be a matter of permission as opposed to a matter of right?
The evidence that I would refer the court to is the trespass law and the efforts in the case law at the time. We have Harkness, which shows that there was a presumption of permissive use. We have various activities or various cases, Pointer, I believe, is one, that refer to efforts to eject people from property. There was not a wholesale understanding that you can go wherever you want, and the law was equipped to eject people or limit their rights to the use of others' lands. That, I think, is the framework in which we would consider this a permissive use or an understanding that it was permissive as opposed to a legal entitlement, because the law provided a method to stop people from using property that they did not own.
But there was a period in which there were no trespass laws. That's Ms. Quist's argument, right?
There's the question of there was an absence of criminal trespass laws. There were statutes or other laws that allowed for recovery of injury to property resulting from trespass. And as evidenced by Harkness and Pointer and a variety of other cases, I would refer the court to pages 8 to 12 of the amicus brief and the cases cited therein, which evidence a framework for civil ejectment actions and civil protection of the right to exclude. The right to exclude has commonly been understood to be one of the most prominent sticks in the bundle that comprise private property rights. And there was a framework at the time for a private landowner to exercise that, even if it was not in a criminal context, simply for walking on another's land.
Are any of those examples, are there examples of people using that right, of landowners using that right of ejectment to stop people from using the water on their property, including wading in the water, touching the stream bed? Do you have any examples of that?
I think the closest I get is Pointer and the other case that I'm trying to remember right now, where it was involved the land between the meander line and the water of Utah Lake, where someone had built structures on that land when it was submerged, and when the lake receded, it changed the property line in the patent, and the property owner succeeded in ejecting those structures from that. I'm not aware of any pre-Constitution litigation involving this question. I think if there was litigation, we would probably have found it by now, and maybe we wouldn't be here.
So in terms of the public understanding of the law, there's not really dispute that the public used the waterways, and the scope of that use included touching the riverbeds, and we don't have examples of them being prohibited from doing that. It wasn't illegal, it was legal. We don't have examples of anyone being excluded from private land when they were using the riverbeds, wading in the water. We don't have any examples of that.
No, we don't have any examples of that, but we also don't have any examples of the contrary, which is an individual seeking to enforce that right.
Except for widespread public use.
Excuse me.
They're doing it.
But as Judge
And they're
Orm,
being permitted to do it by landowners and courts and.
but we don't have any example that that was an enforceable interest in land at the time of the Constitution, which is the full scope of the threshold question.
Wouldn't we only have examples of that if anyone tried to stop them from doing it? So doesn't the fact that we don't have examples of anyone stopping them from doing it, what does that tell us?
I don't know that that tells us that it amounts to an easement, because in Harkness, all we could see is that easement could be by condemnation. If the state or the territory had determined to condemn all of those riverbeds, that would have created that interest. If there was prescriptive use, if they had used it for a period of 20 years openly and notoriously and hostilely, they could go in and they could prove that. Or it could be dedicated by agreement with the landowners and documented. And those are the methods by which an enforceable interest in the land could have been created, which is different than saying nobody cared, because we need that enforceable interest in land, or this is not a question of Article 20.
I guess one thing I'm trying to understand with that argument, I understand what you're saying. Can you help me understand how that doesn't boil down the threshold question to just what was the law at the time?
Well, for exactly the reasons that I stated when I was describing Harkness. So for example, there could have been an application of facts that show, perhaps they could go show 20 years of consecutive use on a particular stream, or perhaps those facts could have given rise to, a claim of prescription on certain stream beds. But we're not talking about one stream bed, we're talking about them all. Under the old English common law system, perhaps custom and usage would have gone there, but that was rejected. That was not the law at the time. That was clear from Harkness. It's clear from jurisprudence all over. And so those facts, maybe there are facts out there, maybe there were, that could meet one of those standards, but these facts don't.
And so in your framing, the threshold question is, if we're litigating a case back at that time, there needs to be a demonstration that there was an enforceable easement right. And if we can't put that together with the legal standard and facts to support it, then the appellants don't meet the threshold question. Am I
That's correct.
getting that right? Okay, I want to
Okay.
make sure I understood that.
I'm happy to answer any other questions, but I've far exceeded my time and would like to hand over to the state unless there are further
Does
questions.
anyone have any other questions? Okay,
Thank you.
Andrew Dimick for the state of Utah. Council's right. Justice Hagan is right. The threshold question is not a constitutional question. It's a question of whether there was an easement as statehood. And there's been some questions about the role of public understanding. I want to start by looking at how the court worded the threshold question. It did, when it referred to understanding, it did not use the term public understanding. It said understanding of easements. And you can contrast that with how the court worded a later question, the interpretation of the constitutional text lands of the state. At that point, Justice Lee, who's very precise and careful, used the phrase public understanding. So the court recognizes a distinction between those two things. Now, I'd like the court to consider, the courts don't ask, or questions of whether there's a right or a duty are for the court. If it's not for the jury. These are questions of law. They may involve the application of fact to law, but they are ultimately questions of law. And the coalition on page 23 of their reply brief states the coalition does not challenge the necessity of application of the legal standard to the relevant facts. And that was essential under 19th century law. The state notes in its brief that there was a statute of frauds in the 19th century, under which, unless there was a written conveyance, no interest in real property arises except by operation of law. And USAC's position below was that the threshold question was a mixed question of fact and law, which by longstanding definition, and which is undisputed here based on this admission in the reply, requires the application of the facts to a legal standard. They did not provide Judge Pullen a legal standard on summary judgment. What they did was they told Judge Pullen explicitly. They brought forward a lot of facts, but they explained to Judge Pullen what it meant. They said, these facts show that the early LDS pioneers believed they had this right based on their religious principles. USAC did not show that there was any law from which the pioneers could have this belief. USAC told the district court explicitly that we are rooting our claim to easement in these early LDS principles, including the principle of divine ownership of land. Although they're downplaying it, that's where it's still rooted, because they have not provided this court, even assuming it's preserved, a legal standard to apply to the facts that will create an easement. The district court correctly determined they lacked a legal basis for their claimed easement. And this, as I said, was driven by USAC's position below. this court is reviewing whether Judge Pullen correctly granted summary judgment. And based on their arguments to Judge Pullen, he certainly did. He was faced with an argument that their claimed easement was rooted in LDS principles.
Well, and common understanding of the time and general usage and practice. I mean, the religious element was a piece of that, but I don't think it's fair to elevate that to being the driving force behind their argument. That was obviously an important part of the perspective of the day.
It was, but they used the term rooted when referring to the LDS principles. And some of them were communitarian, but what they emphasize is the principle of divine ownership of land, which was certainly a religious principle.
But talk about it in terms of public understanding, because I recognize the threshold question is not necessarily asking for a constitutional interpretation, but that's the context of all of this, and public understanding is the most important thing that we try to understand within this context. So no, religious doctrine does not create necessarily law or enforceable easements, but if you speak of this as public understanding, why is that irrelevant to your argument?
Because their understanding was based on their religious principles and practices. It wasn't based on any law that they can point to. USAC admits to you here on appeal that they cannot cite to any law under that established this condenser easement. And under the statute of frauds that was existed in the 19th century, they need to show that an interest in land arose by operation of law. And that's where they failed below. They could not provide the district court any law. And so he correctly granted summary judgment on that basis. And again, this was driven by their position. Their position below was that this is a mixed question of law and fact. And their position, which they've repeated in their reply, is that they do not challenge the necessity of application of a legal standard to the relevant facts. So you can't fault Judge Pullen. He took their position. He noted that they could not cite to any law under which an easement arose, and for that reason, he correctly granted summary judgment. And I would like to also bring in the presumption of constitutionality. The presumption of constitutionality does apply in this context, as shown by this court's recent Inland Port case, in which this court applied the presumption in reviewing a grant of summary judgment of a constitutional claim. Under the presumption of constitutionality, this court doesn't strike down statutes unless a plaintiff has clearly shown that they are unconstitutional. And this threshold question is an essential step in the course of showing that the Public Water Access Act is unconstitutional. Now, in the presumption of constitution, yes, Your Honor.
Are we getting ahead of ourselves a bit on that? I've wondered about whether we should apply the presumption of constitutionality at this stage, but I mean, VR could win at this stage, and you know, the constitutional heavy lifting would come on remand when the Article 20 questions are considered. Why does the constitutional presumption apply at this stage?
Well, this showing the threshold question is part of their constitutional challenge. It's an integral and essential part of USAC demonstrating that the Public Water Access Act is unconstitutional. And here we are after 12 years, and they still cannot identify any legal standard on which this easement arose, which is essential, as they admit on page 43 of their reply, that they have to, that a legal standard is essential. And so
I get that, but what, I don't understand what constitutional issue we're considering at this point. It seems to me that that's explicitly bifurcated. Our task at this point is to assess whether there's a factual and legal basis for the existence of a Connacher type easement in the late 19th century. Admittedly, we depending on how we rule, we have to get into the constitutional issues. I guess I'm just pushing back a little bit on whether the state is entitled to a presumption at this point.
this threshold question is an essential component of their constitutional claim. They cannot demonstrate it unless they demonstrate the threshold question. And so that's why the state believes that the presumption should apply. We're
But
12
they could
years.
demonstrate it. They could win on the threshold question and still lose on the constitutional question, correct?
That's they can prevail. Yes, Your Honor.
You're right. They can't ultimately win unless they satisfy the question. My question only goes, I admit that it's a step in the eventual process, and that it may mean that we either get to or don't get to the constitutional question. I'm just wondering about, this to me is an important question as to whether the presumption applies at this stage. But I think I understand your position on this. Thank you, Mr. Dimick.
Are there any other questions? Okay, thank you.
Thank you, Your Honor.
Thank you, Your Honors. We believe that this court is able to review the record, the historical basis that the coalition offered to answer the threshold question in the affirmative. Connacher doesn't say that there was not a constitutional right, Justice, like you noted. It says that the issue was not previously decided. It also stated that it was based on modern case law. That statement ignored its citation to Adams, which was a 1936 case that recognized territorial ownership of public water. Judge Orm, I wanted to go back to your question about neighborly usage. And I wanted to remind you of the record's citations to territorial commercial usage. We made a showing that a lot of the territorial usage was commercial. Floating of logs and other commercial uses, that wasn't necessarily just a communal, come in, use our river, we're good with that. It was a different standard. It was a different, a commercial-based necessity that was part of living on the water that this community was doing.
But a perception that the community would have shared, we want to make the desert blossom as a rose, people are moving in.
Right.
We need logs. What better use of our river than to float these logs down from the Uintas to Provo and the sawmill, or however that worked? I'm not sure that the community would have perceived that use as being on a fundamentally different footing than the neighbor boys coming over to catch fish.
Well, but everybody probably didn't agree with the logs that jammed up the entire rivers for months at a time during a certain period of time. And yet it was protected. It was a protected use of the rivers because it was a necessary commercial use of the rivers, and the community protected it. And there were no cases that decried that use or that denied that use. The cases that were brought up, Pointer and other ejectment cases, didn't deal with the use of water. They certainly didn't deal with the use of public water. In fact, the Buford court case, where there was an ejectment case, a right to exclude from private property to the access public property, showed that even you could fence your own private property, and keep a herd of 200,000 sheep from causing damage, but you couldn't access, even if you had other private property within tracts of public property, you could not limit access to that other public property. And in fact, the Supreme Court, the Utah Supreme Court and the United States Supreme Court was astonished at the gall of the appellants to come in and try to limit the access to that public property. But again, those cases also didn't deal with public water.
Let me ask a quick question that
Yeah.
I think was begged by Mr. Dimick's argument. I mean, what is the legal standard that a court in the late 19th century would have applied to find an easement here?
Well, I mean, the legal standard would have been the only one that we know, because there are no cases that we have. And the only one that we know was referenced in Adams, which stated that there were, quote, existing rights to public waters at statehood. That means that those existing rights existed at statehood, which means they existed before statehood. And so if such a case had came up, I mean, we don't know what the court would have applied, but we know that there were rights that the public had to water, to beneficial use of the water, and any touching of the water bed would be incidental. I mean, I can't say what because we don't have those cases. But we do know that according to Adams, there were, quote, existing rights at statehood.
But do you agree that the only claim before us, or the only issue before us, is whether there was an easement at the time of statehood? Not that there was some maybe constitutional right or inherent right, but that there was an easement.
I agree that the question before us is whether there was a legal framework that would have supported a Conitzer-like easement at the time of statehood.
So right now, we have no constitutional question before us. Is that correct?
Correct.
The only thing we're deciding is whether there was a legal easement to touch the stream beds would have been recognized at the time of statehood.
Yes.
Okay.
Yep. And we believe that we've made that showing within the legal framework within the legal framework that we've shown.
But it does require a small leap. I mean, ultimately, your argument is that the order of the day, the perception, the public's right, the sustained usage and so on, is consistent with and reflects an understanding of easement.
Yes.
How else could it have happened but for being a product of an easement?
Yes. Yes, Your Honor. I am out of time. If there are any more questions. Oh, yes, Chief Justice.
Question. So I wanted to dig in a little bit deeper on your trespass argument. You point to the fact that there was a period in which there were no trespass laws as evidence of the public's understanding. State says, well, evidence is one thing, source is another. Our prior opinion required you to identify a source, not just evidence. And I've kind of struggled with which way the trespass laws point. I wonder if the pervasive usage of streams by the public in the late 19th century was part and parcel of the kind of general zeitgeist, maybe religiously based in the notion of divine ownership of property, is that, you don't do any damage, fine. Walk across our land, walk across our stream beds. And that wouldn't give rise to I don't know, but I wouldn't think the public would have a sense, maybe they did, I don't know, I'll get your response to this, that they had even independent of the stream bed question, which I understand is different given the nature of water, but would they have had a sense of an easement to, say, cross lands for their own purposes?
I think eventually there were, you know, a sense of easements to cross lands. I mean, the private property, you know, developed, obviously, and so their trespass laws developed, yes.
So maybe they didn't think necessarily, if we're trying to probe the 19th century collective mind, maybe they didn't think there's something special about stream beds. We can touch those. They might have thought, you know, it's land is land, and nobody's in the spirit of our religious community. We're not going to exclude people from our lands, be they stream beds or, you know, regular land. Is that fair?
I think that's fair, especially in the West and in Utah particularly for the fishing, hunting. At this time, you can't fish, you can't use these rivers without stepping in the stream beds.
Yeah, I guess I just wonder if it proves too much. Why doesn't it?
I'm sorry, I didn't catch that last part.
I'm sorry. I guess I just wonder if it proves too much. Why doesn't it?
Why doesn't it prove too much? I don't think the absence of trespass laws. I mean, I think the absence of trespass laws shows that early Utahns weren't prosecuting for this type of behavior.
I guess, and maybe I'm asking it not very clearly, but if someone brought a claim today and argued that even private land, independent of or unrelated to stream beds, private land was land accepted by the state because it was the general understanding of 19th century Utahns that people could cross private land without fear of any attempt to exclude or trespass prosecution. Why would that argument fail?
I think they would have to show a general purpose, or you know, a general purpose in a beneficial general purpose in their right to do so. That's wherein our purpose lies. You know, you have I'm thinking of like Antelope Island, perhaps. You know, you've got private property up there, and you've got a big fenced, and I want to go up there and walk across it with my kids, and we're not gonna injure anything, and I'm not gonna leave a diaper there from my 8-year-old. I just told everyone he's still in diapers, and he is, but you know, I'm not gonna leave his diaper there, and we're not gonna harm anything, you know, but I have no communal or a public reason to get from point A to point B and walk across it, even though they could in 1888. I think it's a different scenario than what we're talking about now, you know, as opposed to maybe if there's, you know, on Antelope Island, if it's the only way, if there's no other roads around to get from A to B, and on B, there's a lookout to, I don't know what's on the other side, you know, and it's like an amazing place, and everybody comes to see it, and there's a communal public property reason, or you know, perhaps that's a reason why there's a reason for people to cross the public property or the private property. But just me and my family crossing the private property, I would say there's no reason to. There's no communal property beneficial reason to do so. But I think that's a different hypothetical than what we're talking about today.
Yeah,
And-
maybe
and,
it's
uh,
just that water's,
And water's a whole other story.
water's special. It's in a different category.
Yes.
Are
Yep.
there any other questions? Chief, do you have any more?
Oh, I'm done. Thank you.
Okay. Thank you, Ms. Quist.
Thank you very much.
Okay, we will be in recess to reconfigure the court.
Would all
We're
those present in
adjourned.
the courtroom please rise?